Well, everybody, I was right. You were pissed. I didn't want to be right, but I was right. And today we saw it happen in the Supreme Court. So let's get into it. Let's talk about it. Welcome to Late Night with the Gringo. All right, everybody. Well, about 3 or 4 months ago, I made a video about birthright citizenship and the executive order put up by President Trump, and I explained to you I didn't necessarily agree with President Trump, but I tried to explain to everybody exactly how his administration was going to argue against the 14th Amendment and try to fundamentally change what it means to be a U.S. citizen, or at least the requirements to be a U.S. citizen, and it triggered and pissed off a lot of you. But I was right. And today, they did exactly that in the U.S. Supreme Court, of all places. The 14th Amendment was argued against in the U.S. Supreme Court today by Trump's Solicitor General, General Sauer. And of course, it was defended by the Solicitor General for New Jersey, who represented, amongst other 23 states that filed suit against this particular executive order. But to understand everything that went on today, we have to understand the beginning. And really, what's the beginning? The beginning is President Trump's executive order from January. So let's just put it here. As it is right now, if you're born in the United States, you're a citizen of the country. You're also a citizen of the state in which you're born in. And those two things cannot be divided. And if you're born in the state of Massachusetts and you're also born in the country, so you're a U.S. citizen, it means that the state of California cannot deny you your citizenship. It can't say you're not a citizen. If President Trump has his way right now with this executive order, that could all change. You think I'm joking? You think I'm being hyperbolic? Well, that's exactly what was argued today in front of the 9 justices of the Supreme Court. And I'm not sure which way it's going to go. Based on listening, now, I want to thank everybody for joining me this morning. We had a Supreme Court listening party because you can't watch the Supreme Court. They don't allow cameras in there. But the oral arguments are always broadcast live over the U.S. Supreme Court website. And so we had a listening party. We talked about it as it went on. We tried to figure out which justice was speaking at which term because they don't really tell you. You just kind of have to know them by voice. And I really want to thank everybody for joining me. I know it was early, but that's how government works. So with that, let's go back to the beginning and let's just have a little bit of a refresher because we have to have a little bit of history because history played a big part in today's oral arguments. And when I say history, I mean they went back, the justices and the lawyers were going as far back as 1789 and common English law in order to support their arguments for and against what they were arguing. And it wasn't necessarily entirely about birthright citizenship. This case this might be the most important case of President Trump's 2 presidencies. Never mind the first one. This might be more important than impeachment because depending on how this case is ruled, it could spell the end of his domestic agenda when it comes to executive orders, or it could just say to him, you got free reign, buddy, do what you want. And unless the Congress stops you or it makes its way to the Supreme Court, you're good to go. So there is a lot riding on this case. I mean, this is a massive case, one that will be historic, one that will have implications on future presidencies, one that will have implications on future executive orders. So, yeah, oh boy, it's a thing. Let me tell you, it is a thing. So, let's get into it. Let me transition here and let me get you here. All right. Again, the one thing I will say, again, I'm not a zealot. I'm not a hater. Sometimes he does things I'm like, yeah, it makes sense. Sometimes he does things I'm like, what in the frig are you doing, President Trump? All right. So back on January 20th, basically his first day in office, 2025, basically right after he took the oath of office, he signed this executive order amongst many And this one's called Protecting the Meaning and Value of American Citizenship. And it was immediately challenged in courts. And at least 3 or 4 separate judges around the country just said, you cannot do this. This is unconstitutional. So what it does, the purpose, the privilege of the United States citizenship is a priceless and profound gift. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Now, the part that they really kind of right here, the subject to the jurisdiction thereof, and let me just explain that. If you are, and I've explained this before, but I'm explaining it again. If you're the ambassador, if you're a citizen of France, you're the ambassador of France, you come over to the United States, your wife is pregnant, she gives birth in a hospital in New York City, your child is not a U.S. citizen because you're not the subject thereof. Your child is a French citizen. Well, they're arguing sort of the same sort of precedent and a couple other things. We'll get into the merit of the case later on. But they're arguing the same thing as if you're an illegal alien, you cross over the border illegally, you're not the subject thereof of the United States because you've never taken an oath of citizenship, residency, whatever, all that. You don't have a domicile, all that stuff, right? So therefore, you cannot have a child be called, if you give the birth to them, like say over the state line of Texas, they're not a Texan. They're still a citizen of wherever that mother came from. So basically, the policy. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize the United States citizenship to persons, one, when that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. Pretty simple. Your mother's an illegal alien, so are you when you're born. Doesn't matter where you're born. Unless your father is a citizen or a resident. When that person's mother's presence in the United States was lawful but temporary, and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. So even if your mother's here on a visa, it's a temporary visa, you're not a citizen of the United States. You don't get it. Again, we've just read the 14th Amendment. This seems in contradictory to the 14th Amendment. At least I would think so. All right. It's a 30-day window for this order, which we'll get into because that's a problem. All right. Enforcement, the state, Secretary of State, the Attorney General, all that, blah, blah, blah. Definitions. Mother means the immediate female biological progenitor. Father means the immediate male biological progenitor, all that stuff. Okay. So that's the executive order. So what is the 14th Amendment? For those of you that are out there that just kind of really don't know what the 14th Amendment is, don't remember your high school history class, the 14th Amendment is one of the 3 main Civil War amendments passed by the United States Congress. All right, the 14th Amendment has a lot into it, but basically it's the birthright clause. It's the Birthright Amendment. It was created and written by John Binghamton, congressman from Ohio, who was concerned because he was alive when the Dred Scott case occurred before the Civil War. The Dred Scott case being the case in which a slave ran away from their plantation. They ran to a free state, and they said, well, now I'm free. Well, they got arrested, they got caught, and there was the argument that, hey, I'm in a free state. I should have the same rights. And the Dred Scott case went all the way to the U.S. Supreme Court, and in their total rejection of wisdom, they basically said, no, slaves are property, so therefore they don't have the rights. So the 14th Amendment was made specifically by John Binghamton to say that that slaves who were freed and the children of those slaves who were born on this soil are U.S. citizens. You cannot take away their rights. You lost the Civil War, you can't take away their rights still, okay? It was to protect those people. Now, has that expanded? Now, of course, when that amendment was being argued and it was being debated in Congress, there were those in Congress who stood up and said, we can't have this whole blanket birthright citizenship thing going on because, well, you gypsies can just come over and just, now they're American citizens and all that. There was those arguments then as there are now. Still, the amendment passed. And it's been precedent since then, since post-Civil War America. And then it was once again challenged in 1897 and 1898. The case was decided. Wong Kim Ark. It's the case that everybody cites. It's the case that I cited back in January. And it's the case that gives the government a little bit of an opening. And this is where I argued where Trump thinks he's right, and all of you got pissed off, and some of you, because it's unbelievable. Believe me, I have a stake in this fight too. All right, I don't want to see this happen, but I'm just explaining to everybody exactly where President Trump is going to argue this, and argued it today. Argued against the 14th Amendment. So Wong Kim Ark, basically 2 Chinese immigrants come over. They're here for 20 years. They are living in San Francisco. They have a business. They have a domicile. They pay their taxes. They have residency, right? Immigration laws were very different back then. They have a child here. He's born in the United States. He grows up in the United States. His name is Wong Kim Ark. After 20 years, the parents decide, look, we want to retire. We're going to go back to the homeland in China. So Wong Kim Ark says, I'm going to escort you there. 2 weeks later, gets them settled, comes back to San Francisco, and they say to you, you can't come in. You're not a U.S. citizen. And he said, no, I was born here. This is my house is here. So it makes it all the way to the Supreme Court. This poor bastard had to go all the way to the Supreme Court to get his citizenship back. So they argued that because he had a domicile, because the parents were domiciled, that was one of the key arguments in Wong Kim Ark. They were domiciled. They had a residency. However, they were an established thing. They were established life. That, yes, he was a citizenship. The clause protects, the 14th Amendment protects him. Now, and this has been time and tested again and again and again and again. There have been multiple cases again and again and again. But they've all involved some sort of residency, some sort of domicile, some sort of establishment. What Trump argued today, what his Solicitor General argued today, and he specifically said it in his rebuttal, he went it all the way to the end, that all these cases, because even Sotomayor really hammered him and said, listen, you're arguing as 4 precedent cases which you shouldn't be arguing about, they're established. Well, guess what? He literally said to her, well, all those cases involve a domicile, a residency, an establishment. Therefore, they don't apply to people who just come over the border illegally. Therefore, the 14th Amendment does not apply to them. I can't make this up, folks. They were literally arguing against the 14th Amendment. Now, whether you feel that this is a good thing, a bad thing, you know what? Let me know in the comment section below. Maybe you think that this is the correct way to go about things. This is the correct way to do things, right? So we're going to get into some of the arguments here. We got some of the stuff queued up. I know it's all Fox News, and just don't worry. It's just they had this stuff up. They're really good with covering the Supreme Court, so I wanted to make sure I had some things up here. But what does it all mean, really? What does all of this mean when it comes to protecting the 14th Amendment? And so the case today wasn't exactly all about the 14th Amendment. It wasn't exactly all about birthright citizenship. Birthright citizenship was the package in which the argument was wrapped, okay? What do I mean by that? The Trump administration asked for this hearing. It's an emergency hearing. Very rarely will the U.S. Supreme Court add something on in May. They did today, and all 9 heard. The bigger issue is that there have been 40 injunctions made by judges around the country in certain areas to say, President Trump, those executive orders are illegal, they're unconstitutional, they're unlawful, they're not applicable, you can't go forward with them. And therefore, the Trump administration has a problem with a solo judge, say in Seattle or San Francisco or wherever, saying to them, here's a universal injunction that's going to cover the entire United States. And they're saying, well, you can't do that. That's an overreach of the power of the judiciary, and you can't do that because it's taking away power from the executive. It's unconstitutional. Fair enough. Okay, I can see that argument. I can understand that argument. But what happens now is if the Supreme Court decides, hey, you know what? You're right. Judges can't do this. District judges can't do this. Federal judges can't, right? They can't do this. Then it means it's wide open for the executive orders that President Trump has written to go into effect and maybe have class action lawsuits against them later on that will eventually have to make their way to the Supreme Court again. Well, the state's Solicitor General, the Attorney General also for New Jersey and 23 other states, well, they brought suit as well. And they said, we're going to argue against this. And so that's who we saw today, the Solicitor General of New Jersey, arguing very eloquently, by the way. I was very, very impressed with the way in which he spoke. the way in which he articulated his argument. Now, don't get me wrong. The justices, mostly the three progressives and a couple of the conservatives, hammered the Trump administration. It was uncomfortable, hammering, questioning, because he really didn't have a leg to stand on, because he's fighting against 150 years of precedent, of legal precedent. He's fighting against that. And they're like, hey, throw us a bone here, but you know what? I mean, it is what it is. The state's attorney generals and the state solicitor had a much easier time. They were much more welcoming, much more there was much more of a dialogue between him and the justices. And of course, one of the things they argued is this. Well, if the executive order goes into effect and someone was born in the state of, say, New York, and New York now has their own rules for what a U.S. citizen is, based on some federal guidelines and things like that. But say Texas, slightly different. Does that mean if that person flies from New York City to Houston, Texas, the minute they land in Houston, Texas, they're no longer a U.S. citizen? That is crazy. What does it mean for babies being, and he brought up the example. There are 6,000 babies born every year to New Jersey residents outside the state of New Jersey because they're traveling, vacation, whatever, right? Well, how do you reconcile those? Are these babies now only citizens of the states in which they were born? And how do they become citizens of New Jersey? Like, what is that? How does that happen? How does that occur? What about the administrative costs? Are we going to have people just in hospitals? Their job is basically like, hey, I know you just gave birth, but can I see your papers? Is your child actually legal? And what about people who have already been granted citizenship or are considered U.S. citizens because they were born on U.S. soil to illegal immigrants? Do they lose their U.S. citizenship? They just might. Can you imagine that? How many people could lose their citizenship if this executive order goes into effect? It really is an executive order that is trying to wipe away the first section of the 14th Amendment from the Civil War. One that was made to combat the evils of slavery, one that was made to combat the evils of human rights abuses, and one that was made in the context of trying to make this country more welcoming and opening place. But yes, you heard the current president's administration argue against the 14th Amendment of the Constitution today. I didn't think it would happen. But again, and here's how I saw it with the questioning. We're going to get into some of it because, first of all, Sonia Sotomayor was not having any of this crap. She was just not. She literally said to the Trump administration Solicitor General, General Salary, she said, you wouldn't dare bring the merits of the case of birthright citizenship alone to this court. You wouldn't dare do that because you know you would lose. Literally said that to him right then and there in open court. I think, is she wrong? I don't know. Justice Thomas seemed as quiet as usual. He doesn't usually ask many questions. He asked a couple. They really didn't, but he's usually more conservative. Justice Alito was a little bit more focused on the question of how many district judges there are. He had a great quote. There's 680 judges around the country, district judges, and they all think they're a king, and they all think they have this great power. Maybe we shouldn't have that. Now, why do we have so many executive orders, and why do we have so many universal injunctions by judges as of late? That was one of the big topics today. Why? Because universal injunctions have been a thing since 1963. They're kind of recent in political history. But they're even more recent now because you have more executive orders. Why? Congress does shit. It's hard to get Congress to get together to do anything, let alone pass a bill. So the president comes in, whoever that president is. Biden had a shitload of executive orders. Trump has more than any in the first 100 days of any other presidency. He had a ton in his first administration. Obama had a ton because they're trying to get things done with, and as the judge says, as Alito said, they all have good intentions. They all want to make the country better. They all want to get something done. And they can't count on the legislature to do it because the legislature doesn't move. So you have all these executive orders, and now you have all these lawsuits everywhere. And you have all these injunctions. So, Supreme Court takes on birthright citizenship. Justice is seemingly split on lower court powers. I would say that is an inaccurate headline. A very inaccurate headline. I would say the three progressive justices or liberal justices, Sotomayor, Kagan, and Ketanji Jackson Brown, Though they're not siding with the Trump administration whatsoever. No way, ain't happening. You could tell that from their line of questions. Ketanji Brown Jackson was just like, why are you here, to the Trump administration? Literally asking the Trump administration, listen, so what you're saying is a judge says something is illegal and you're like, nah, it's fine. We're going to do it anyways. You don't have to obey that. And the Solicitor General jumped around the question a little bit, kind of gave a half answer, said, oh yeah, we'll listen to the judges unless we think they're wrong. And still Ketanji Brown Jackson was like, listen, if a judge says something is illegal, doesn't that, and they say it's illegal for one person, doesn't that mean it's illegal for everybody? That was the other part. The Trump administration was saying, listen, if a judge says, if someone comes into court and they say, the Trump administration has done something illegal, it's affecting me negatively, I want relief. And the judge says, yeah, you're right, you get relief. The Trump administration says that judge's ruling is only effective to that one person, that everyone else in the whole country has to find their own lawyer and file their own lawsuit. It was ridiculous. I mean, the argument, the legal acrobatics, the legal gymnastics in my head to try and figure out exactly how they came up with this idea, it was amazing. And again, there's some things that Trump has done I think were great. Some things we can point out that, hey, I think, yeah, he did really good with that. This, no. This is ridiculous. This is silly. All right? This is silly. This is just a bridge too far for me. Because if one president can write an executive order overriding the 14th Amendment, can another one coming up next write an executive order overriding the second? Maybe someone overrides the first. Maybe someone overrides, I don't know, the 19th, women can't vote anymore. And that's really what's at stake here. And that's what we have to figure out. That's what the Supreme Court has to figure out. So the Supreme Court struggled to reach consensus Thursday in oral arguments involving President Donald Trump's effort to end birthright citizenship in a case that could more broadly call into question the powers of lower courts to block executive branch actions. Basically, the Trump administration is like, yeah, only the Supreme Court can block our actions. And even then, we might not listen to you. All right? Now, the focus in the courtroom ostensibly was the birthright citizenship executive order Trump signed on his first day back in office. Okay? Justices across the ideological spectrum appeared to agree Thursday that the use of universal injunctions has surged in recent years under both Democrat and Republican presidents. But after more than 2 hours of oral arguments, they seem split on how exactly to proceed. Yeah, they don't even know how to proceed. They're like, listen, the judge says it's illegal. Why? What's the problem? Right? So do I think the Trump administration is going to win this case? No. No. But let's listen in on something. Here we have every court ruled against. This is Emilia Kagan. Right, this goes on for a couple of minutes here, so we'll turn this up. Let me put.
I don't think there's a, so to speak, really, really unconstitutional exception to the strictures of Article 3 or the scope of equitable authority, and the court should not recognize one, because what we see, not just in this case, but in the 39 others, is that
what you're hearing is the Solicitor General argue against the judiciary power. And he's about to get questioned or commented on by Emilia Kagan. So this is the Trump administration speaking. The gentleman with the froggy voice. I don't know if he was sick. I don't know if that's his real voice, but he was struggling.
the district courts who are issuing these injunctions all passionately disagree with the thing that's being challenged in that. So that principle that, well, this we think is really unconstitutional, therefore we should ignore the general principles of Article 3 is not a principle the court ought to adopt.
Justice Kagan?
So, General, on this question of expedition, I mean, it sort of depends on the government's own actions in a case like this one, where one can expect that there is not going to be a great deal of disagreement among the lower courts. I mean, let's assume that you lose in the lower courts pretty uniformly, as you have been losing on this issue, and that you never take.
Just to interrupt, she's absolutely correct. On the issue of birthright citizenship, there have been 3 or 4 judges that have basically heard the case on lower courts, and they all said, no. The Trump administration has lost repeatedly over and over and over again in different justices. Right? And she's basically like, what do you want us to do about it? You keep losing. You're just a sore loser at this point with this.
Take this question to us. I mean, I noticed that you didn't take the substantive question to us. You only took the nationwide injunction question to us. I mean, why would you take the substantive question to us? You're losing a bunch of cases, this guy over here, this woman over here, you know, they'll have to be treated as citizens, but nobody else will. Why would you ever take this case to us?
Well, in this particular case, we have deliberately not presented the merits to this court on the question of the scope of remedies, because, of course, that makes it a clean vehicle where the court doesn't have to look at the past.
You're ignoring the import of my question. I'm suggesting that in a case in which the government is losing constantly, there's nobody else who's going to appeal, they're winning, it's up to you to decide whether to take this case to us. If I were in your shoes, there's no way I'd approach the Supreme Court with this case. So you just...
And that's one of the quotes of the day. There's no way I would bring this case. You've lost and lost and lost and lost. You have 150 years of legal precedent against you. And now you're trying to get around, instead of coming to us and saying, we want to argue birthright citizenship. No, we want to argue the power of the judiciary to be able to stop us. They're basically trying to circumvent the idea of actually having to argue the merits of the birthright citizenship. And Elena Kagan's right. There's no way. I mean, there is no way that they would have the guts, the balls, the moxie, I don't think you could find a lawyer willing to walk into the Supreme Court to argue that, because it's just a losing battle. And they all know it. And Emilia Kagan's pointing it out. And again, she's a liberal justice. Like her, don't like her. And I've said this about her and Justice Sotomayor. There are a lot of things the two of them say or argue or come down with opinions. And I'm like, I don't agree with that, but they're both brilliant. They're absolutely brilliant justices. And they do know the law. And she's right. Kagan's right. There's no way you're bringing this case against us because you want to complain about judges instead of coming to us and say, we want to talk about the merits of birthright citizenship, because they know they would lose.
Just keep on losing in the lower courts. And what's supposed to happen to prevent that?
Again, I respectfully disagree with that forecast of the merits, but in response to the question, what I would say is, we have an adversarial system, and if the government is not, for example, not respecting circuit precedent on the court's hypothetical in the Second Circuit, someone injured in the Second Circuit could take the case up, and they could say, look, the government is violating circuit precedent on the hypothetical multiple circuits.
That's the case we're going to take? Somebody who says, you know, after we've said that this all has to be done one by one by one, then we're going to take a case from somebody who objects to proceeding one by one by one?
I'm not sure I understand the question. I understood the hypothetical.
If you win this challenge and say there is no nationwide injunction and it all has to be through individual cases, then I can't see how an individual who is not, you know, being treated equivalently to the individual who brought the case would have any ability to bring the substantive question to us.
They would bring a lawsuit in the federal district courts against the...
Let me explain what she's arguing. And I know it's a little convoluted, but what she's saying to him is that the Trump administration, again, like I explained a couple minutes ago, is arguing that, okay, there can't just be one universal injunction that covers everybody, that covers an entire class of people. Get rid of that. And everyone who's got an issue is going to come up with their own lawyer, file their own lawsuit, and go through their own legal process. Really? because everybody's got the money to do that. Because everybody's got the time to do that. Because that makes sense, right? There's a reason we have class action lawsuits, right? It's so we can protect certain classes. It's called Route 23B2, and they speak about it greatly during these 2 hours of arguments. But the Trump administration is saying, no, it'll be fine. Everybody can get their own lawyer. Everybody just file their own lawsuit one-to-one. Again, I don't see the logic here. I don't think there is logic here. And I think it's a perversion of what the court system is really all about at this point. And again, Kagan hammered him. Sotomayor hammered him. Ketanji Brown Jackson hammered him. And then he lost Amy Coney Barrett. When you lose Amy Coney Barrett, one of the conservative justices, when you start to lose her, I'm like, okay, you probably lost her. You probably lost Chief Justice Roberts. There's your 5-4 decision, whether the other four decide to argue. I think this is going to be more 6-3, 7-2. I just can't see this going forward. But anyways, I could be wrong. The court surprised me in the past. I didn't think they were going to overturn Roe v. Wade, but they did. But hey, here we go.
The government for an injunction protecting them. And if the government wasn't respecting, on the
Yeah,
hypothetical
and then
circuit
and then
precedent,
they win. And again, I mean, you need somebody to lose, but nobody's going to lose in this case. It's just you're going to have like individual by individual by individual, and all of those individuals are going to win. And the ones who can't afford to go to court, they're the ones who are going to lose.
the tools that are provided to address hypotheticals like this, again,
This is not a hypothetical. This is happening out there, right? Every court has ruled against you.
we've only had snap judgments on the merits. Obviously, we're fully briefing the
Snap judgment on the merits. Basically, he's saying we haven't had full arguments. We haven't had this. The judge just reads the argument, kind of goes, okay, what is it? And he kind of makes his own decision, saying the judge is just making snap judgments without even thinking, snap judgments without even consulting, snap judgments without even wondering how it affects the Constitution. And really, basically, they're saying the judges are just out of control. They're saying the judges are out of control. They're wielding their power in an unruly way. And again, they could be. Even one of the justices here, Justice Alito, we'll hear about that later, says the same thing, but all of them are coming up with the same ruling. That's the problem.
merits in the courts of appeals, and our arguments are compelling. More fundamentally, in response to the question,
I'm suggesting to you, like the real brunt of my question is, in a case like this, the government has no incentive to bring this case to the Supreme Court because it's not really losing anything.
Yeah. Not really losing anything. And what does she mean by that? She's like, the government's like, yeah, every individual needs to get. Imagine that. You've got, say, 10 million people that need to file their own various lawsuits to say, I'm really a U.S. citizen. And the government's saying, no, you're not. So you got 10 million. I mean, how long is it going to take to get through 10 million cases? These people will be dead. Okay, let's not even worry about whether they can afford a lawyer, afford the court case, afford the loss in their income because they're going to lose their job, their benefits, or whatever, whatnot, because they were a U.S. citizen, now they're not. Again, how long? These people will die. People will die before they get their court hearing. And she's literally arguing. She's like, literally, that's what you're arguing. That's literally what the Trump administration is arguing. It's almost like we're going to get rid of your citizenship through attrition. We're going to watch you die off first. Okay, well, this one, Sotomayor, she was heated. She was not happy. She was not happy. And even at one point, Chief Justice Roberts sort of had to step in and be like, maybe kind of bring it back, reel it in. I mean, at some point in time, I felt like Sotomayor was leaning over the counter, leaning over the dais at the Solicitor General, just ready to just throttle him for even having them bring this case. But listen, this is a little bit longer, but let's listen.
I'm sorry. Here, there's a discrete identified group on one issue. Does citizenship mean, are you born in the territory of the United States? Or does it mean, are you loyal to someone else, which is your claim? Or are your parents loyal to someone else? So that's no different than what happened in a Bill of Peace.
Again, the Trump administration would like to argue that if you're an illegal alien, you're a mother, you're pregnant, you roll over the border, however, whatever, right? Not, you've not taken any type of oath of citizenship, residency, you've not had any court hearings, whatnot. You're just here illegally. You have no loyalty or no jurisdiction subject thereof of the United States. You're still a subject or under the jurisdiction of whatever country you came for. Therefore, your child is under the subject or jurisdiction of whatever country you just came for, and therefore you're not a citizen. Now, what the justice here is trying to argue is like, listen, these are a class of people we've already defined. And now you're arguing against that class definition. And so how are you going to get around that? How are you arguing this? Like, what is the mechanism for which you are trying to delete this whole labeling and definition of people? So
The United States is bigger, so it extends more broadly, but it's still an identifiable group on a discrete, singular question.
Your Honor, I'd say three things in response to that. First of all, our primary contention is that the citizenship clause related to the children of former slaves, not to illegal aliens who weren't even present as a discrete class at that time, but more fundamentally here as to...
Again, he just said exactly what I told you all back in January. I know some of you, it pissed you off. I told you that's how they were going to argue it. I didn't agree with it, but I told you that is what they were going to argue. They were going to argue that the 14th Amendment is rested in historical context and does not stretch beyond that historical context. It's only for freed slaves. Therefore, who needs the 14th Amendment anymore? We don't have slaves in here anymore, right? No more slaves. So your 14th Amendment shouldn't even apply to anybody, is what they are arguing. That's his first answer. He's got two more, and by the time he gets done, Sotomayor's had enough.
To the issue of the Bill of Peace, there are critical differences. The Bill of Peace was a binding judgment that would bind.
Okay, let me explain this too. Bill of Peace is something they use a lot. Bill of Peace is basically a class action lawsuit. It's basically saying if you've got 100 people with the same issue, they can file one lawsuit together to get remedy. They don't have to file separate 100 lawsuits. That's what the Bill of Peace is talking about. And basically he's saying, yeah, well, you know what? The Bill of Peace covers them later on. If they want to try to file a lawsuit, then we can argue against it. Basically, he's forcing everybody who's already considered a citizen under the 14th Amendment, who from illegal aliens, to try to actually go back and form a class action lawsuit. You can't make this stuff up, folks. 2025 America, you can't make it up.
Absent class members. Here we have the ace.
Well, here, class actions don't bind anyone who opts out. So class actions are not like bills of peace.
I would think that a Rule 23b2 class action, which would be the relevant analog here, would be one that would be binding on absent class members and would not have the same notice and opt-out procedures. And more fundamentally, that sort of argument that there's a commonality here among, all the people who purport to be affected by this is the sort of argument that's made in class certification.
So can I ask you a question? Your theory here is arguing that Article 3 and principles of equity both prohibit federal courts from issuing universal injunctions. Do I have your argument correct?
We argue both of those.
You argue both of those?
Yeah.
If that's true, that means even the Supreme Court doesn't have that power.
The Supreme Court would have the authority to issue binding precedent nationwide, but as
But
this
we
court
couldn't enforce it against universally, is your...
There's the heart of the matter. Sotomayor's like, basically you're saying the Supreme Court is powerless. Basically, courts are powerless. Basically, the Trump administration is arguing that Article 3 of the U.S. Constitution is just there. Doesn't really mean anything. Has no binding power universally. Individually, sure. But universally, it doesn't. And 23b2, again, is that Bill of Peace class action lawsuit. And that's an important piece of law that is getting damaged by the Trump administration arguing this fact. Basically, let's go back to the issue that 100 people are filing a lawsuit, class action, right? But let's say there's 1,000 people who are in the same situation. Those 1,000 people don't need to file the same lawsuit because once those 100 people win, that class action lawsuit under Rule 23b2 covers those same people. They get that same relief. They don't have to go to the courts and argue just for them. But again, that's what the Trump administration is arguing against, is that, yes, all 1,000 need to come. And you thought the court systems were slow now.
Your argument.
if there was a decision that violated the precedent of the court, then the affected plaintiffs could get a separate judgment.
And
So
that
is what
means
this court-
you're talking about the hundreds and thousands of people who weren't part of the judgment of the court. They would all have to file individual actions?
Not necessarily. There
Or,
are
or a class action?
a class action would be the way
Isn't
that,
that makes no sense whatsoever.
respectfully, we believe that.
Well, what was the purpose of the Bill of Peace if not to settle a legal question finally? And if even the Supreme Court doesn't have that right and must invite hundreds of thousands of lawsuits, what are we buying into?
If a set of claims satisfies the rigorous criteria of Rule 23, Rule 23 is the modern analog of a Bill of Peace. We have something very different here.
No, we don't, because the argument here is that the president is violating an established, not just one, but by my count, 4 established Supreme Court precedents. We have the one ARC case where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally, if you're born here, you're a citizen. We have yet another case that says even if your parents came here and were stopped at the border, but you were born in our territory, you're still a citizen. And we have another case that says even if your parents secured citizenship illegally, you're still a citizen. So as far as I see it, this order violates 4 Supreme Court.
It's kind of hard to argue against that. Those are real cases. It seems pretty covered. I can't think of right. It seems pretty covered that the Supreme Court has already stated exactly the opposite of what the executive order that President Trump wrote on January 20th and signed on January 20th. I don't know I don't know what they're doing in the Supreme Court trying to argue against this, but they are. But they're trying to circumvent it by trying to go after judges. They're trying to eliminate the judiciary. They're trying to eliminate the court system. That's a very dangerous thing. It's extremely dangerous.
Court precedents.
Yeah, we
And you are claiming that not just the Supreme Court, that both the Supreme Court and no lower court can stop an executive from universally from violating those holdings by this court.
We are not claiming that because we're conceding that there could be an inappropriate case.
Only a
Rule
class,
23
only
class
by
action.
Can I hear the rest of his answer?
A Rule 23 class action. And then the more fundamental point as to all those Supreme Court decisions you referred to.
So what do we do temporarily?
Temporarily, the court may issue, the lower courts may issue injunctions that remediate the injuries to the plaintiffs that appear before them. Lower courts, in appropriate cases, may certify class action.
So when a new president orders that because there's so much gun violence going on in the country, and he comes in and he says, I have the right to take away the guns from everyone, then people, and he sends out the military to seize everyone's guns, we and the courts have to sit back and wait until every named plaintiff or every plaintiff whose gun is taken comes into court.
In appropriate cases, courts have certified class actions on an emergency basis. We found at least 4 cases in recent years where that was done. But more fundamentally, we profoundly disagree with the characterization of the merits. This is now fully briefed in the Ninth Circuit in case number 25-807, where
he doesn't answer her question. He doesn't answer her question. He goes back to his original argument, which doesn't answer her question. It's a great question. Yeah, it's a gotcha question. Yeah, it's a trap question. What happens when a president comes in and writes an executive order to take away all your guns and uses the military to do it? Courts can't do nothing about it? The Supreme Court can't step in and say, no. Federal judge can't step in and say, no. He doesn't answer the question. Again, this is a very dangerous thing they're arguing. Very dangerous thing. Taking away judicial power, judicial review. Judicial review has been established since Marbury versus Madison in the mid-1800s or early 1800s. The idea that the courts can look over laws passed, executive orders, actions, and say, does this violate the Constitution? Yes or no? I mean, are we going to get rid of that precedent at this point in time? Which is what they're arguing. And what she's asking, she's like, are we getting rid of judicial review? Then what's the point of us being here? In case you wanted to know, that is Sotomayor. She's a little bit older. She's probably going to be one of the next ones to, I doubt she's going to retire while Trump's in office. This is Chief Justice John Roberts, who interrupted her because she's so just, you could tell she's just had enough of it. To her, this is all BS. But Justice Roberts wanted to hear the entire the entire answer, so interrupted her, had to rein her back in a little bit. But you could tell that she was just like not having it. And this is the Solicitor General. This is John Sauer, the Solicitor General, the gentleman with the froggy kind of voice that's arguing in favor of what the Trump administration wants. But yeah, you can just tell that, hey, you don't have Kagan. Kagan's not a yes vote on this. She's just like, this is ridiculous. All right. This is ridiculous. All right. Here we go.
U.S. Supreme Court.
Nope, that's not what we want. So at one point in time, I don't have the audio for this, so I'm going to get the words and read it to you. At one point in time, Justice Alito, who's typically a conservative, can be every now and again a swing. Not really, but he's typically a conservative. Really kind of let me think that maybe he and Thomas are going to have a dissenting opinion in favor of the Trump administration, where he said, we have 680, I'll remember it off the top of my head. He goes, we have 680 federal judges, district judges around the country. And he goes, sometimes they have the judicial disease. And that's what he called it. Judicial disease, where they think that when you come into the courtroom, they're all powerful, they're the king of the county and all that, and what they say goes and all that. And yes, he goes, this is true, that we have judges that seem to think that their power is almighty, and they exercise it and wield it through he goes, it seems like it's a typical trend within the district court level. He goes, but eventually those things make their way to the Supreme Court. That's how it's supposed to work. But he goes, I understand you're concerned with all these judges making universal injunctions that cover the entire country, that block executive power and executive authority, which makes me think that he has some sympathy for the Trump administration. So I could see him ruling in their favor in this. What he also said, which was interesting, and Justice Gorsuch also said it today, they asked one of the other people arguing, a young woman arguing in the case on behalf of an organization that represents immigrants. They asked her, I said, hey, would you have a problem if we just ruled on birthright citizenship right now without even hearing the case? Basically what they asked her. And politically, she basically said, well, no, we'd want to hear the case, blah, blah, blah. But in reality, I think the justices are getting ready to say, listen, we'll rule in favor of saying some of these injunctions can't stand. Some of them can. There's going to be like a little split decision kind of. It's going to be a very murky decision. But I also think they're going to I think they're going to issue a decision and say, birthright citizenship, although we've not heard the case, don't even bring it because this is what we think. Don't even bring it. And I think that's a possibility. They call it arguing before certification. Making a decision about a case that they think they can make a decision about before hearing any arguments, before hearing anything, receiving any scrap of evidence, research, whatnot. It's just one of those things that happens very rarely. But there are those times which is like, okay, this issue's pretty cut and dry. We'll just tell you what we think right now so you don't waste our time, your time, the country's time. So I do expect that there will be a separate decision at some point in time, whether it's in a few days or a few weeks. We don't know what their timing is. I'm betting it's going to be sooner rather than later. But I bet we're going to get something that says, hey, that executive order on birthright citizenship, don't even bother. Don't even try. Because we will take it up immediately. We won't even let it go through the court system. We'll just say, yes, we'll take it, and we'll hammer you. And you don't want to get hammered. The last thing Trump, you don't want to be a presidential administration that keeps losing in court. They've lost in court time and time and time and time again, as Sotomayor pointed out, as Kagan pointed out as well. The last thing you want to do is start losing court cases left and right in the Supreme Court. Because when it comes to this, they're going to lose. I just believe they're going to lose. I just don't think that these 9 justices, you're going to find 5 of them that are willing to overturn 150 years of precedent. I just don't think, or overturn the idea of judicial review, or the idea of constitutional conventions and how you want to change it. If you want to change the Constitution, there are processes in place. Those processes are impossible to actually do nowadays. We're too divided of a country. There's no way you get 3/4 of the state legislatures to make a similar decision on a constitutional amendment. No way. It's never going to happen again. Never. Never. Of course, I said there'll never be an American Pope, but there was. But I say never this way because I really do believe never. I don't think you're going to get more than half the country's state legislature say, yeah, we'll do that. Or that type of voting process in the state Senate or the House to have a new amendment, create a new amendment, or alter the Constitution in such a way. It would have to be done by legislative process. The Congress would have to write a new law for citizenship and say, this is how we define citizenship. Then it would probably get challenged in the courts and get struck down because of the 14th Amendment. Again, the 14th Amendment, when it was argued in Congress back in the 1800s, you had similar people saying, well, that everybody who just comes across the border and has a kid, and they were referring to gypsies, well, now they're American citizens. That's not right. Same argument then as it is now. It lost then. It's going to lose now. But that's the executive order. So the Supreme Court took this up. Now, if for some reason, and there's a big if for some reason the court decides to neuter the judicial system itself, I can't see them doing that. If the court decides to say, hey, yeah, you're right. There's way too many activist judges, because that could happen. And there are too many activist judges, but this isn't the way to deal with them. But there are too many. So if the Supreme Court, if you say you got Thomas Alito, Gorsuch, Amy Coney Barrett, and for somehow, some way, some reason, you're able to swing Chief Justice Roberts as the fifth vote, then Trump's executive orders will have no challenge to them, unless they come in the form of some massive class action lawsuit, which will take years and be stuck in the court. And if they lose at the lower court, then they'll just appeal at the next court and appeal at the next one and appeal to years and years, 5. They even the Supreme Court today said, listen, it takes 5, 6, 7 years for cases to reach us, because they have to, that word percolate, right? That's a word you heard today a lot, percolate. And that's what the government actually asked. They said, we want the government, the Solicitor General, the guy with the frog was like, we want things to percolate. Basically, he wants to slow things down. He wants things to take time. They want to stalemate everybody. Percolate means, all right, you get the lowest court, they hear the case, someone who wins, someone who loses, they appeal to the next one. Somebody wins, somebody loses, they appeal to the appellate court, then the federal courts, then the federal appellate court, and then the Supreme Court of whatever state they're in, and then and then whatever, and then finally they get, if the Supreme Court decides to hear it, it'll get there. You're talking years, because you can file motion after motion to delay this and to delay that. And that's really what they're playing with. That's really what part of the Trump administration's game here is. Delay. I don't agree with it. Again, this is one of those issues where I look at the Trump administration and I'm like, fucking stop. Right? You got wars all over the world. You've got an economy that still needs help. You've got all sorts of issues with international relations. You got all sorts of issues with crime. You got all sorts of issues with poverty and homeless and all this stuff. Leave the 14th Amendment alone right now, okay? That's gravy. That's later on, all right? That's your conservative. Again, I'm a moderate. I lean conservative. I'm a conservative just saying, please, leave it alone. This is one of those things where it just shouldn't be, because you're setting, I hate it when we set precedent because we're so in a hurry to get done what we want to get done. We don't think about the implications on the next guy and the next generation and the generation after that and the generation after that. Because again, the Supreme Court, in this argument, they went all the way back to 1789. They were talking about case law from 1789. Common law, English law. This stuff lasts forever. It lasts forever. But here you go. The Supreme Court arguing today. Again, one of the most pivotal, important cases we'll ever see, at least in the next 20 years. I can't think of anything more important coming up. Then the idea of whether or not the Article 3 of the Constitution has any teeth or any bearing, any merit. Judicial review, does it have any bearing, any merit? It's one of the most important cases you'll hear. And it's one we should all pay attention to. And it will define the Trump presidency for the next 3 years. It will absolutely define it. At least domestic policy-wise, it'll define it. So there you go. But let me know what you think in the comment section. Good, bad, indifferent, care, don't care. You think it's a good idea? You think it's a bad idea? You think it's about time? You think that this is an overreach? Everybody's opinion is different. Everybody's going to have a different opinion, but apparently it comes down to the 9 people there, their opinion. And hopefully, I don't know if the Trump administration is going to follow. It sounds like they're like, the courts say one thing, we do something else because, we don't agree with it. That's not how the country's supposed to work. That's not how the Constitution's set up. So if you are a Republican and you're a conservative, we're really big to say to my fellow conservatives, we're really big on saying you must follow the Constitution. You must follow the rule of law. You can't interpret the Constitution. It is what it is. Well, except to here when it doesn't really let you do the things you want to do. That type of hypocrisy doesn't fly, I think, with real conservatives. And I think real conservatives would agree that this is a case that should never have made the Supreme Court. But with that. So yeah, that was the news of the day. I really appreciate everybody joining me. This has been Late Night with the Gringo. I'm going to sign off. It's actually really late here. It's late. I'll be back tomorrow during the day, during the afternoon, around noon, 12:30 with South of the Border. And then later on, Friday night with some streaming. We like to play some video games, have some fun because it's all not doom and gloom. We like to have some fun too. So I'll be back tomorrow, and I really just appreciate everybody joining in. And again, let me know what you think. Let me know if you think I'm wrong. Maybe you think I'm right. But with that, I'm going to sign off from South of the Border. I'm still your reluctant gringo. Everybody, salud, a huevo, and we're out of here.